Excellent. Good evening, everybody. Thanks for being here. For those of you not watching it live, I'm sorry you missed it, but here's your chance to see it. So welcome. So we've really called this, I've been named a fiduciary, now what? Well, I think first of all, we have to look at what is a fiduciary. And a fiduciary is someone special in the law who has the responsibility to act in the best interests of the person that they're acting as a fiduciary for. Fiduciary has some special language in the law, and it gives you some responsibility. But there's really four types of fiduciary appointments in estate planning, and that's power of attorney, healthcare power of attorney, executor or executrix, and trustee. So you've been appointed a power of attorney. So now what? Well, what is a power of attorney? You know, your loved one has entrusted you with power of attorney, giving you the legal right to handle their finances, including taxes, bills, and real estate transactions, if they're unable to do so. It's a big responsibility, but what does it mean? Remember, power of attorney only exists during life. It ceases at death. It's possible to be named a power of attorney, also known as an agent or an attorney in fact, and not have any responsibilities at the moment. While the principal is healthy and competent, there's nothing that you need to do as an agent. So you become a power of attorney when the person becomes unable to transact business for themselves. If something happens to the principal, you'll take on these duties, which is the legal term for the loved one who granted you the power of attorney. The principals, that is. Good. The paperwork controls what you do. Your duties should be spelled out in the legal documents called the power of attorney or POA. A power of attorney is most often responsible for financial management and would have access to bank accounts, safe deposit boxes, estate documents, and could make decisions about purchasing insurance, government benefits, and filing tax return. It also depends if the power of attorney is general or limited. Now, most power of attorneys we do are general, durable power of attorneys. General means it covers a lot of topics, right? As opposed to limited. Limited would mean maybe, for example, I give you limited power of attorney to just renew my plates on my car. That would be limited. Durable means it lasts your entire lifetime. Whether you're competent or incompetent, this becomes effective even if you're incompetent. Most power of attorneys we do are durable. I would say most, I would say all. All power of attorneys we do are durable. A power of attorney agent must make decisions in the best interests of the principal, which means acting in accordance with their expectations, acting in good faith, and limiting your role to the scope of the responsibilities you were granted. Conflicts of interest could include transferring assets to your name, borrowing or lending money, or making changes to their estate. Some power of attorneys will not allow you to transfer assets to yourself or limit borrowing or lending powers. And usually making changes to the estate is usually not something that's in power of attorneys. You may have the power to create a trust, but it should be in accordance with the wishes of the person who made them. Potential penalties for violating them. Power of attorneys have fiduciary responsibilities, and violating those duties can result in criminal or civil charges. I had a power of attorney once. The woman came in and she said, I want to revoke my power of attorney. And I said, okay, we can do that. Tell me, you know, a little bit about the situation. And her niece kept nudging her, saying, go ahead and tell him, Auntie, tell him, Auntie. And she said, no, be quiet. Well, of course, I had to know then what was going on. And she gave power of attorney to her nephew. Her nephew had an attorney that he knew, prepared the document, and he took every penny from her. I said, well, we should probably pursue him because he could have criminal or civil liability. And she said, oh, no, he didn't mean to do that, which is just astonishing to me. But she decided not to pursue him. And but it's a point that it's a very powerful document. And the people you appoint have to be responsible themselves. When it comes to signing documents on behalf of your loved one, remember to sign as their agent. It needs to be clear that you are acting as power of attorney, which could mean signing in a specific format such as Jane Smith by John Jones, comma, agent, or comma, POA. Ask about any preferred format for your signature before signing, And remember to bring your power of attorney documents when conducting transactions in this role. It's important to remember that you have to have the original power of attorney in order to act and transact business. So if you are appointed a power of attorney, it's not a bad idea to have your power of attorney have an original of that document. If not, because a lot of people choose not to do that, which is absolutely okay, just make sure your agent knows where the power of attorney is located and how to access it. How many people keep it in their safe deposit boxes and then the power of attorney has no access to the safe deposit box? It causes problems. So hopefully you have shared with your power of attorney where that document is. Also, keep careful records. You'll need to document all financial transactions, including receipts of bills paid, income collected, and assets sold or traded. Maintaining a paper trail reduces your liability. Keeping records is especially important if you are claiming compensation for taking on the role. You need to document how much you were paid and justification for the compensation. For example, if you made a 50-mile round trip to conduct a transaction, you'll need to document the mileage, save gas receipts, and document the standard IRS mileage rate. Most power of attorneys don't take compensation for being power of attorney, but it's absolutely allowable by law and usually spelled out in the power of attorney. Remember, ask for help. If you're unsure about your responsibilities or need guidance in carrying out your fiduciary duties, just call us. We don't charge for phone calls, and so I'd love to hear from you. Any issues you're having, we'll be happy to help you along the way. The lawyer who created the power of attorney is a good place to start. Your job is to protect your loved one's best interest while protecting yourself from liability. Again, call us, call us, call us. That's the main gist of this slide, right? Good. You've been appointed a healthcare power of attorney. In New York, they call it a healthcare proxy. And I like to use the word proxy because I don't want to confuse the power of attorney with the healthcare power of attorney. A healthcare power of attorney does just that. It allows you to make healthcare decisions for the person when they're unable to. The healthcare agent is the person responsible for making medical decisions on your behalf, following directions you've set out in your healthcare power of attorney. Also sometimes called a medical power of attorney or power of attorney for healthcare. Who can be a healthcare agent? A healthcare agent must be a person and cannot be an institution or a healthcare provider who's currently treating you. I have a lot of people, and I used to have a friend who was an attorney. He passed away, but he used to encourage people to make their primary care physician their healthcare power of attorney. And I don't know many doctors who want that liability, and so it's usually not a good idea to appoint them. What are my duties as a healthcare power of attorney? There are several decisions you'll be capable of making as a healthcare proxy. Choices about medical care, including medical tests, medicine, or surgery. The right to request to decline life support treatments. The right to apply for Medicare, Medicaid, or other programs or insurance benefits on the person's behalf. The option to take legal action on the person's behalf in order to advocate for his or her healthcare rights and wishes. And finally, choices about where the person will receive medical treatment, including the right to relocate the person to another facility. These are all things that the power of attorney provides, and it's a little more expanded than just making healthcare decisions, right? What are my duties as a healthcare proxy? You are also responsible for fundamentally managing the person's medical care, which may include learning about the person's medical condition and treatment options, reviewing the person's medical chart, communicating with the person's family about his or her condition and treatment plan, requesting and coordinating second opinions or outside medical care. You know, it's interesting because maybe we appoint one child as healthcare power of attorney, but let's say there's 2 or 3 other children. It's good to talk to these people, right? And get their opinions as well, even though you're responsible for the decision. Because if there's a conflict, it's usually a good idea to work out that conflict. And that's, again, where we come in and hopefully we'll be able to help resolve any conflict. How should I prepare for my role as a healthcare power of attorney? Well, your job is to advocate for the person you're representing, which means you need to know his or her decisions and beliefs and values around life, end of life, and healthcare preferences. Learning these preferences while the person is still able to convey his or her wishes is crucial. It's important that you ask the right questions. Good questions to ask are, does the person have any ongoing medical issues, such as chronic conditions? Are there any drugs or medical treatments that the person would prefer not to receive, and why? Does the person care more about living as long as possible or being as comfortable as possible? Does the person have religious or spiritual values that will affect the type of care or treatments he or she would like to receive? Would the person like to have a palliative care team or hospice team care for him or her at the end of life? Are there specific life support treatments that the person knows he or she would like to receive or would not like to receive? See, these are all conversations that once we do the healthcare power of attorney, that this conversation should take place. Things you'll need to figure out if the principal becomes ill. Well, what is the person's medical situation? You need to talk to the person's doctor and supporting medical staff and learn the facts. What is the usual course of this disease? And is a doctor who specializes in this disease involved in treatment of the person? If not, should a specialist be brought in? Next, what are the person's treatment options? What is the goal of this treatment? What is the likelihood that this treatment will be successful? And what does success mean? Does this definition of success correspond with the person's values? That's very important. And what would the person I'm representing want me to do in this situation? Okay, you've been appointed an executor or an executrix. Now what? Well, what is an executor of a will? Simply put, an executor of a will is someone who manages the deceased person's estate and is expected to distribute the property to the beneficiaries by following the instructions of the decedent, that is, the person who passed away. And what is a will? A will is a document that names who gets your stuff and who is in charge. That's the executor. And remember, we all call it stuff in our office because it's no matter how valuable or important, it's just stuff. You can't take it with you. Remember, a will only controls what you own in your name only when you die, and a will must go through probate. See, if I have a joint account, let's say my wife and I own an account together, it goes to my wife when I die, no probate. If I have a beneficiary on an account, it goes to that beneficiary or beneficiaries without probate. But if I own something in my name only, then it goes by the will and through probate. And what is probate? Well, it's a legal process. It's the state rules. Every state is different. And it's delay, right? It takes a minimum of 7 to 9 months to go through probate. And the control is with the court, not with the family. And your information is public. All your personal information is public. And finally, this is the reason why most people say they want to avoid probate, and that's the cost. AARP did a study that says it costs anywhere from 5 to 10% of your estate. And I would say that's probably pretty accurate. So you can tell why most people want to avoid probate. What does an executor of a will do? Being the executor of a will comes with many duties, including execute a petition to probate the will and make sure that all persons required by law are notified of the probate proceeding. You see, we have people who are in the will that need to be notified, and there might be people who would have taken if there was no will, they also need to be notified of the probate. They then have 3 months in the state of Ohio to conduct a will contest, and that is contesting the validity of the will. Next, keeping the deceased person's assets safe until they're properly be distributed to those named in the will or creditors. Any creditor is susceptible to what's in probate. So if you have a trust and you've funded it and everything's out of probate, creditors cannot claim what's in a trust in Ohio, only what's in probate. Next, you have to decide what assets and property to sell and what to keep. That can be challenging, although most people usually sell most things, divide up the personal effects, and then distribute the money. And finally, contacting people in the will to make sure they get their inheritance inheritance, and wrapping up financial affairs of the decedent, like canceling credit cards, filing tax returns. All those things need to be done by the executor. Does an executor get paid? That should say and, not and. Usually, since it involves a lot of hard work and stress, the executor can waive their fees. You see, in Ohio, you are absolutely entitled to a fee. And the only way to get around not taking the fee is to waive that fee. An executor in Ohio is entitled to be repaid for any out-of-pocket expenses and lawyer fees incurred, and the estate will repay them before the beneficiaries receive their shares. And unless otherwise stated in the will, the executor is entitled to be paid a commission for serving as the personal representative of the estate. The executor fee set forth in the statute in Ohio, the commission rate in Ohio for each executor is 4.5% of the first 100,000 in the estate, 3.5% of the next 300,000, and 2.5% of any amount above. Family members serving as executor often choose not to be paid, and any commissions are considered taxable income. So when they know they have to report it as income, most people don't take an executor fee. How to protect the deceased person's wishes. As the executor of a will, it is your responsibility to ensure that the deceased person's wishes are being upheld and you're taking your executor of a will checklist seriously. You should also research what your executor of a will duties are, hire a lawyer, an accountant for guidance, and protect your deceased one's assets above all else. You have the duty to preserve and not waste the assets in the estate. And when I say waste, I've had people use an estate account as a personal checking account. It's not how it works. It's not how it should work. And that money would have to be repaid if you did such a thing. And lastly, you've been appointed to appointed trustee or a successor trustee. What is a trust? First, in law, trust is a relationship where property is held by one party for the benefit of another party. A trust is created by the owner, also called a settlor, trustor, or what I use is grantor, who transfers property to a trustee. The trustee holds that property for the trust benefits. Now, as many of you know, you can be your own trustee in most cases, and therefore during your lifetime, you have full control of the assets. It's only when you pass that a successor trustee is appointed. See, a trust is to me just a little red wagon. It's a vehicle to put your stuff to ensure who gets it, when, and how. And that's the basis of estate planning. So not only do we want to avoid probate, but we want to ensure that our beneficiaries receive protected money. And so we also give your beneficiaries trusts and not money. That beneficiary trust protects them from their divorce, creditors, lawsuits, nursing homes, all those fun things that could happen. But remember, you see this picture, it's all got all the boxes in there. We don't want to see any boxes outside the wagon. And the boxes represent your house, the car, whatever, you name it. So funding is important. And if you haven't fully funded your trust, now is the time. Get in touch with us and we'll help you fund. Revocable versus irrevocable trust. A revocable living trust, or what we call an RLT, the terms can be changed at any time. Assets can be transferred in and out of trust at any time. It's very flexible, but does not provide asset protection under debtor-creditor laws. Due to its flexibility, there's no limitation, no restriction to the grantor. They can basically do whatever they want. Irrevocable trusts provide asset protection from creditors and predators. But you give up the one thing that you most want to protect while maintaining control of the assets. You can retain the right to income, and you can direct where the money is invested. You can give assets or income to and change beneficiaries. You can avoid taxes by giving up right to principal and income. And the only thing you cannot do is reclaim ownership of the principal or asset. Because if you can touch it, the principal that is, then so can the creditors, lawsuits, nursing homes, etc. So there is a bit of a stipulation on irrevocable, but we do a lot of irrevocable grantor trusts. So for all of you numbers people out there, tax people out there, we don't have to file a separate tax return. It gets all reported on your personal tax return. And so those are the things we want to know about irrevocable trusts. Why would someone set up a trust? Well, first, to manage and control spending and investments in order to protect beneficiaries from poor judgment and waste. You know, how many times do we have someone who maybe has a son or a daughter that's addicted to drugs? We can't leave them in control of their money. If they do, we know where it'll go. And so therefore, we want to make sure that we have someone in charge of their funds to ensure that nothing bad will happen. Same thing with disability, right? When we have someone who's disabled, we want to make sure we protect those assets from them as well. We also want to avoid court supervised probate of trust assets and be private. We want this to be in the family room, not in the courtroom. We also want to protect trust assets from the beneficiary's creditors and to reduce income taxes or shelter assets from estate and transfer taxes. Now, remember, in Ohio, we've eliminated the inheritance tax, which is awesome. And the federal limit right now is about $12.9 million per person. So we really don't worry about estate and transfer taxes in Ohio anymore. And finally, to qualify for public benefits while protecting assets from long-term care costs. One of the main reasons people set up irrevocable grantor trusts is to ensure that their money will be protected from long-term care costs. What is a trustee? A trustee is someone who holds and administers property rights for the benefit of another person. The latter gives a trustee these property rights by signing a legal document. You might say a trustee is a stand-in for a person and has specific legal authority to act on the latter's behalf. A trustee is the manager of the trust that they've created, or the trust of someone else. The role of the trustee acts as a legal owner of trust assets and is responsible for handling any of the assets held in trust, tax filings for the trust, and distributing the assets according to the terms of the trust. Both roles involve duties that are legally required. You know, how many people that I have just tried to administer the trust on their own and have ended up in litigation with the beneficiaries or just problems in general. So we need to be involved in the administration of a trust. And it's important to remember that the trust assets belong to the trust and not the trustees. Trustees are prohibited from using the trust assets for their own benefit unless the trust specifically authorizes such action. A trust functions through its appointed trustees, and the legal personality thereof requires that all trustees act together for and on behalf of the trust. The initial trustees are appointed by the donor of the formation of the trust, and thereafter, when an existing trustee resigns or is replaced by a successor trustee, in accordance with the provisions of the relevant trust. It is important for trustees to ensure that they are correctly appointed and their future trustees are also appointed. One of the big benefits of doing a trust is that when a spouse passes, there's not a lot the surviving spouse has to do. Because we funded it correctly, it's a very simple process. What are the fiduciary duties of a trustee? The trustees stand in a fiduciary relationship to the beneficiaries. This is the crucial difference between trustees and directors of companies. For the latter, only owe their fiduciary duties to the company, not the shareholders. A trustee, on the other hand, has a relationship with all the beneficiaries. The fiduciary relationship entails that a trustee shall, in relation to the trust, the beneficiaries and other trustees, act honestly and in good faith, which includes that he or she shall exercise such powers as she or he may have to, manage or represent the trust in the interests and for the benefit of the beneficiaries as a whole. Simply put, that means you have a responsibility to beneficiaries. So we have to do an accounting and make sure that everything is proper and done properly before distributing assets. Computing the trustee compensation, the fees for paying out. Ohio trustees' fees are based on commissions. They are not done on a flat basis. The trustee gets two kinds of fees, paying out fees and annual fees. Can a trustee be personally liable? A trustee is personally liable for a breach of his or her fiduciary duties. The trustee's fiduciary duties include a duty of loyalty, a duty of prudence, and subsidiary duties. Excuse me. The duty of loyalty requires that the trustee administer the trust solely in the interest of the beneficiaries. So can you be held liable? Absolutely. It's why you should have an attorney on your side. What do you need to know about trustee fees in Ohio? Well, acting as a trustee is a job that can take a lot of time and effort. Trustees can take commissions as compensation for their time that they spend handling the trust. Understanding how trust commissions work is an essential part of acting as a trustee, yet they can get complicated. Calculating commissions incorrectly can end up getting a trustee into hot water if it ends up that he made a mistake in his favor. Whenever someone makes you a trustee, you should make sure that you have an Ohio state attorney on your side to assist you in duties to make sure that you do things in accordance with the law. I guess I said that earlier, but you get the idea. We want to make sure that you have an attorney involved. So we want you to contact us with any questions about your estate plans and really want to thank you for attending. So at this point, what I would ask is if we have any questions out there, I would take those now. If not, then we will wrap it up for tonight. Hopefully this was a good use of your time. Again, I think it's a general overview of what people need to do. So if you have questions, you can either unmute or put it in the chat, either way. And I just want to say thank you for all of you watching the recording, and for all of you out there, have a great night.
Hey, Matt,
Yes,
when I was working with Karen to set up the trust and the wills and everything else, I asked her at that time, should I distribute copies of all these documents to the people that are going to be named in them? And
Yeah.
she said, not really. And what's your statement on that?
so I agree. I would say it's not necessary, but also we don't forget we have that portal. So if you do want to share documents, you can log into the portal, give your login to whoever you want, and they can access those documents 24/7. That's probably the best way to do it, just so they don't have this big, thick binder of their own. But again, we can use copies of everything. It's just that general durable power of attorney that they need the original of. So I've kind of changed our mentality a little bit on that, in that if it's okay with you, it's okay with me to have them have an original of the power of attorney. But that's something you have to make the decision.
Well, I've let them all know where everything is, and it is
Good.
in a safe.
Good.
But I was thinking about making copies and having those in their hands.
Yeah.
So that they can get at the originals if they needed them.
Yeah, absolutely. And like I said, that portal, if you're not set up on the portal, call Mary. She'll get you
Yeah,
set.
I had trouble getting into the portal last time I
Oh,
went in.
that's right. I remember that. We even emailed, didn't we?
Yes,
Yes, and I don't know what that problem is, and I can't resolve it. So what I'm gonna do is go back in and take you off the portal and put you back on, so you're gonna get a new login and try it one more time and maybe.
well, it worked. She did that and it
Oh.
worked.
Oh, okay.
She was actually out of town at the time, and whoever was standing in for her took care of it, so.
Oh, good, good,
But
good.
I'll try it. If I don't get it, then I'll come back at you, and then I'll give that
Yeah,
portal to the administrators.
absolutely. Give me a call anytime.
Okay.
Excellent. Any other
Hey,
questions?
Matt.
Yes.
Yeah, I have a quick question for you. Is there a way to kind of name multiple